Kari Lake decision just dropped. The judge deciding that Kari Lake is not going to be the next governor of Arizona. We are going to go through the full under advisement decision. Of course, we spent the full 2 days on the trial unpacking exactly what happened there. A lot of testimony. Lots of it I thought was lacking. I wanted to see those checkboxes checked. And we went through the 2 different counts that Kari Lake was facing. One alleging that there were chain of custody problems. The other was alleging that there was other malfeasance, that somebody was manipulating with the printer tabulators and so on. After 2 full days of trial, the judge came out and issued his opinion. We're going to go through it in detail. Why? Because Kari Lake says she's going to appeal this puppy. Not even waiting around. You see this. She dropped this on Twitter on 12/24 at 11:52 a.m. Kari Lake posted, she said, "My election case provided the world with evidence that proves that our elections are run outside the law. The judge did not rule in our favor. However, for the sake of restoring faith and honesty in our elections, I will appeal his ruling." And so it sounds like she may not have a lot of belief that this is going to go anywhere, but she says, just for the sake of restoring our faith, restoring honesty on our elections, we're going to appeal it. We're going to keep fighting. So let's see what some bases might be for her appeal when we go through the under advisement decision. And it's not too long. We see here, filed 12/24 at 10:45 a.m. out of the Maricopa County Superior Court here in Arizona. Shout out. 10-page document. Peter Thompson is the judge who signed off on it. It is Kari Lake versus Katie Hobbs. We see the lawyers are there. We've got Brian Blem, who was representing Kari Lake, David Gayona, and many others, a whole slew of people representing the government and Katie Hobbs. Judge Thompson took this matter under advisement at the close of trial. He said, "Thank you, everybody, for participating," and we're done. Then on Christmas Eve, this dropped. Judge Thompson writes, "The court has considered the evidence presented at the evidentiary hearing on December 21 and 22, both of which we covered here in depth, including all the exhibits admitted and the testimony of the witnesses." And we didn't see all of the exhibits. Remember, there were affidavits and declarations that were actually filed under seal, and we never got to unpack those. The judge says the court has also read and considered all 220 affidavits attached to the verified petition. The court has also, which is a lot of affidavits, the court has also considered arguments by counsel, and therefore the court issues the following findings and conclusions of law. Now, a big question that came up in this analysis was sort of what are the standards of proof? Who has to show what? Who has the burden of proof? Who has the obligation to provide the evidence, right? Because Kari Lake doesn't have much evidence. Let's just be clear about this. Kari Lake, at this moment, and when she brought this lawsuit, a private citizen, she's got as much power as you or I do. So she doesn't have access to the same materials that the government has. And so we run into this a lot in criminal law. You know, if one of our clients is charged with a DUI, we don't have access to the entire crime lab. We don't know exactly what went on in there or who these people are, how it all works. And so part of our job is to go and investigate it. And they stonewall us at every turn. They say, "Oh, you don't need that," or "You don't need this," or "It's just your fishing expedition," so on and so forth. Very similar here, right? Kari Lake needs access to voter data, and she needs to see all this stuff and inspect that and inspect this. And she really didn't have much access to that. So the question is, how can she sort of prove her case if she can't go and gather evidence? In criminal law, we've got all sorts of obligations, right? You have a confrontation clause, you've got due process and equal protection, constitutional provisions that enable us to get all sorts of material, right? We've got, Brady rules and so on. But with elections, what are those standards? Is it beyond a reasonable doubt? Is it preponderance of the evidence? Beyond a reasonable doubt, right? That's in criminal law. That's a very high standard. In order to convict somebody, you got to go beyond all reasonable doubt. If there's any doubt about a person's innocence or guilt, and it's based in reason, that person's not guilty, because you got to get beyond a reasonable doubt. Very high standard. So what is the election standard? Let's see what the judge says. Throughout the history of Arizona, the bar to overturn an election on the grounds of misconduct has always been a high one, right? Kind of similar to criminal law, like we were talking about. Citing a case back from 1887. Ooh, that's old. It says, it is the object of elections to ascertain a free expression of the will of the voters, and no mere irregularity can be considered unless it be shown that the result has been affected by such irregularity. Now, that was a case back from a territory case right before Arizona was even a state, which happened in the 1900s. In 1887, they were saying that, this has to be more than a mere irregularity. And what were their elections like back then? I don't think they had printer tabulator malfunctions. So I'm not sure what type of issues they were running into. But even back then, they were finding some mere irregularities with their voting. Okay. And I'm sure it was all in person. So what's going on over there? Long history of this stuff. But the point is, this is the standard. Okay. No mere irregularity. The judge continues. Judge says, our territorial Supreme Court back then agreed in 1898 that it is unwise to lay down any rule by which the certainty and accuracy of an election may be jeopardized by reliance upon any proof affecting such results that is not the most clear and conclusive character. Right? So this is old language. Most clear and conclusive character. The official election returns are prima facie evidence of the votes actually cast by the electorate. Another case. This is a 1917 case. So now we're getting a little bit closer. And this is saying that the evidence that is just provided by the final votes is enough that satisfies it, right? It's enough evidence of the votes actually cast. The fact that you've got the votes, the returns, that they're saying that is evidence. So the judge says the burden of proof in any election contest is on the challenger. That means it's Kari Lake's job to prove her claims. This would be like, okay, in a criminal case, in my opinion, this analogy can probably be beaten up a bit, but it would almost be like if you were an innocent person and you had to prove your innocence. You have to go and prove your innocence. The government says, we convicted you. We did everything right. Everything's perfect. And you have to challenge that. Well, you don't have access to the crime lab and the blood results, and you don't have access to billions of dollars of, police officers and utilities and gear and all this stuff. You don't have all of that. So it makes it very hard. That's why we have the presumption of innocence. But with elections, we have the presumption of propriety. So the challenger has to really come in hot. Kari Lake. Now, it's a difficult thing to do, right? It's almost, how's she going to do that when you're alleging fraud and you get certain people up there who are testifying and they don't give you access to anything? In fact, they're still doing their root cause analysis. The duty of specifying and pointing out the alleged irregularities and insufficiencies is a task that should be undertaken by litigants and their counsel, their lawyers, 1948. Right? So both sides now, two things. One, Kari Lake has to actually carry the burden. She's got to prove there was a problem, but also the investigation, the duty of specifying and pointing out the irregularities specifically, they've got to be done by counsel. That's a 1948 case. And so that's a tall order, boy. It's a lot to do, especially if you can't go and just rummage through all the files. It's too bad Elon Musk can't buy the Maricopa County Board of Supervisors and release their emails. We'd see a lot. Now, as for the actions, says the judge, as for the actions of election officials themselves, this court must, you see that in italics, must presume the good faith of their official conduct as a matter of law. So all those people testifying, Valenzuela and Jarrett and all of the other individuals, remember, we covered a lot of them. And if we go back through the archive, we see a bunch of them here. Reynaldo Venezuela, Dr. Kenneth Mayer. We had Richard Barris, the pollster. But these election officials, Reynaldo Valenzuela and Scott Jarrett, these two people, the court is saying we have to presume the good faith of them as a matter of law. It says all reasonable presumptions must favor the validity of an election, and election challengers must prove the elements of their claim by clear and convincing evidence. Very high standard, right? So it's not quite beyond a reasonable doubt, but it's high. The order from the judge, he writes, granting in part Hobbes's motion to dismiss that we read through here, it gave Kari Lake two independent claims for seeking their requested relief. Two bases, which we covered at length here. One, plaintiff has only these options because election contests are purely statutory and they're dependent upon the statutory provisions for their conduct. Judge says, put another way, Kari Lake has no freestanding right to challenge election results based on what the plaintiff believes. Kari Lake can't just file a lawsuit because she believes it was bad, rightly or wrongly, that it went awry on election day. She must, as a matter of law, prove a ground that the legislature has provided for challenging the election, right? She's got to check all of the boxes explicitly. One who would contest an election assumes the burden of showing that this case falls within the terms. The remedy may not be extended. Okay. So the judge is giving us some details to fill in the lines there, but says, Kari Lake's remaining claims after the judge dismissed the other 8 is based on the following grounds. 1, misconduct on the part of election boards or any members thereof in any of the counties in creating the canvass for the state election. The trial here was premised on Kari Lake's theories arising from the second clause concerning an officer making a canvass. Now, the order that came out from the judge allowed the trial to go forward on 2 bases. 1, the claim that ballot on-demand printers, they malfunctioned on election day, that those were intentionally caused and that those changed the outcome. That was count 2. And we read through that at length. And in fact, one of my main criticisms of this entire trial and really the presentation by Kari Lake's lawyers was that they didn't get a name out of this. They needed a name specifically. The judge said, I want a name of an individual in count 2. The malfeasant person was a covered person. Who was that? Well, we didn't get any names out of it. Could have been Reynaldo Valenzuela, unlikely. Could have been Scott Jarrett, maybe more likely because he was there he was running election day stuff. Right? Who's the boss? Who did he control? Who changed the settings? Who sent the email and so on, right? How did you investigate this? What's the final root cause conclusion? And so on. I'm not saying that he was responsible for this or that he knew about it or anything, but they didn't even present an alternative name. Nothing. Or even try to blame him for it or blame anybody else. So they didn't check that box. And number 2, the claim that Maricopa County violated its own election procedures and chain of custody procedures was another possibility. As outlined in the order that the judge sent over previously, there are 4 elements to each claim. Plaintiff need to prove by clear and convincing evidence each element, each one of these check boxes to be successful in the case. So Kari Lake's got to prove the following. 1, that the alleged misconduct, whether the printer irregularities or the failure, was intentional. Now, we got a lot of opinion about that. Remember, Clay Parikh was one of Kari Lake's experts who said, yeah, you can only change those printer settings through script. You've got to bring in somebody else to go in there and change them. And they were testing the day before, and they didn't test any 19-inch ballots. And we also heard from the government, in this case, this was Scott Jarrett, who sort of was not real aware of the 19-inchers the day before. Or maybe he was, and maybe he was lying, on the stand. I don't know. People are asking questions about that. His testimony sort of changed between the 2 days. But the defense didn't hammer him on that, and so he didn't face any real scrutiny on that in court. He's facing a lot of scrutiny on the internet, but not a lot in court. And so all of that continues on. We really got no name out of this. Intentional act, right? Who would have done that? Don't know. So it's a big question on that one. That the misconduct was an intentional act conducted by a person, an officer, somebody participating in the canvass, that the misconduct was intended to change the result of the election, and that the misconduct did change the result of the election. It's a lot. You got to check every one of those. If you miss any one of these boxes, it's game over. So the judge says that it bears mentioning while we're here that because of the requested remedy, which is Kari Lake asking for the set aside of the election, the question that is before the court is of monumental importance to every voter. This is the judge saying, are you asking me to throw out a whole election? Are you serious? All right, let's see. The margin of victory as reported by the official canvass is 17,100 votes, beyond the scope of a required recount. A court setting such a margin aside, as far as the court is able to determine, has never been done in the history of the United States, says this judge, right? And sort of that was my speculation, but I didn't know that that's official. So apparently this judge probably did the research on that. And yeah, I mean, I've not heard of it. Have you heard of anything like that? I haven't, which is why this is always, it's always such a tall order. The judges are just not going to interfere with this. This guy doesn't want this hanging around his neck like an albatross for the rest of his life. Now, rightly or wrongly, right? Say that, call that what, classify that decision however you'd like. This challenge also comes after a hotly contested gubernatorial race and an ongoing tumult over election procedures and legitimacy, a far less uncommon occurrence in this history of our country. The judge says this court acknowledges the anger and the frustration of voters who were subjected to inconvenience and confusion at voter centers as technical problems arose in 2022. But the judge says, this court's duty is not solely to incline an ear to public outcry, and we're not here to listen to your complaints, Arizonans. It is to subject to plaintiffs' claims and defendants' actions to the light of the courtroom and the scrutiny of the law, almost like shining a big spotlight on the issue. And so the judge says we start now. Thompson writes, he says, it was Kari Lake's burden to establish each element by clear and convincing evidence. If Kari Lake herself failed to sustain the burden of proof, then the matter is decided. And so the court begins with Kari Lake's case in chief. Right. And just to illustrate this, you may have heard, in criminal defense law that you might have a case where a defense attorney just sits there, right? He's just kind of twiddling his thumbs and he just lets the prosecution present all of their evidence. And he just says at the end of it, I got no evidence to present. Nothing further, judge, right? And the defense attorney just sits there and the judge says, well, you win. And you go, what? He didn't even present anything. That's because the prosecutor didn't check the boxes, right? If a defense attorney knows that they can't hit one of the elements, you don't have to present any evidence at all. In fact, Katie Hobbs and her team could have just sat there and said nothing. And based on what we saw at trial, pretty sure Kari Lake still would have lost because she didn't check the boxes. Now, let's see what the judge says. Here says Mark Sonaclair, who was the lawyer. And let's refresh our recollection with Mr. Sonaclair. He was on day one of the trial, presented as the lawyer who worked for the NSLB. And Mark Sonaclair was this guy. He said that 50% is not minor.
I believe you mentioned that you visited personally about 10 vote centers.
Yes.
And that the other roving attorneys that you were working with, it was a total of about 115 vote centers in total.
Yes.
And that's 115 out of about, 223 vote centers, correct?
That's correct.
So that's a little over half of the vote centers.
I believe it was 52%.
How are you able to characterize what your the other roving attorneys were experiencing, whether it was similar to what you were experiencing or worse or maybe not as bad? How would you characterize?
Well, I would say that most of the roving attorneys had a similar experience to mine. I can't think of one that had a different experience.
Yeah.
There may be, but for the most part, aggregated together, pretty much everyone had the same experience.
And if somebody were to characterize the events of that day as minor technical difficulties that should be expected in any election, what would you say to that?
I would say that's nonsense. When you have 132, we've been able to document that there were at least 132 vote centers with tabulator problems out of 227, which comes out to about 59%. I don't see how that could be characterized as a small matter.
Yeah, it's not. It's a giant problem. The whole election was problematic, but it was not enough, obviously. Now, let's see what the judge says about Mr. Sonaclair. Judge Thompson writes, he says, the court first considers Mark Sonaclair, roving election attorney with the Republican National Committee. Sonaclair testified that on election day, he went from voter centers on election day all over the place, visited 8 of them. He testified that because of his personal knowledge that, one, the failure of the tabulators was at multiple locations. He said his own personal estimate of the rate of failure was also provided as evidence. He also talked about the efforts of the varying different degrees of efficacy of Maricopa County techs to fix the tabulators. And also, he talked about the frustration of voters in long lines. He testified that the county provided wait times were not accurate and that a much higher number of voter centers suffered from printer tabulator failures than were admitted. Now, the court credits the personal observations of Mr. Sonaclair and does not doubt his knowledge or his veracity. But the court cannot follow Mr. Sonaclair to ascribing intentional misconduct to any party. Sonaclair said at trial that it was common sense that such widespread failures must have been the result of intentional conduct. But this intuition does not square with his own observations. Judge says, for one thing, he says county T-techs being sent to troubleshoot and fix the tabulators are not consistent with a scheme by a person to alter the results of an election. Oh. So because they tried to fix it, it doesn't mean that there was any intentionality in the underlying problem. Okay. Mr. Sonaclair testified to nothing that suggested those tech efforts were anything other than best efforts intended to remedy the problem. Right. So because they tried to fix it after the fact, right? One person who wrote a script who might have reprogrammed all of the tech, they sent techs to go fix it. And that papers over the mistake, right? For intentionality. See how this goes? Second, as Sonaclair himself admitted, he didn't personally observe anything that allowed him to support his intuition that someone had engaged in intentional misconduct. He didn't observe it directly. Third, Sonaclair admitted he has no technical knowledge that would allow him to determine these things. And lastly, Sonaclair admitted he had no personal knowledge of any voter being turned away from the polls as a result of the failures. So as far as evidence of misconduct is concerned, the court finds nothing to substantiate plaintiff's claims of intentional misconduct. And there's not even a name, right? We didn't get any names out of there. So even if he thought that it was intentional, right, you got to attribute intent to a person, and we got no names out of him. Heather Honey. You remember Heather Honey. She's a very good OSINT, OS intelligence, open source intelligence individual. Great testimony from her, botched direct exam from the lawyers. She had a PowerPoint slide and everything, and she wasn't even allowed to go through it from her lawyer. Okay. From Kari Lake's lawyer. But okay. Now, Heather Honey, the court brings up her testimony and says the court next considers Miss Honey. She's a supply chain auditor, a consultant who testified primarily concerning chain of custody. The court again credits Miss Honey's observation and personal knowledge of the early voting ballots. As relevant to misconduct, her testimony makes two main points. One, Honey says that Maricopa County did not produce receipt forms for ballot packets. And two, that an employee of Runbeck averred that Runbeck employees were allowed to submit 50 ballot packets to friends and family, of friends and family into the ballot stream. Okay, so as the ballots were being picked up in the courier boxes, Runbeck employees were just saying, well, I got a couple extra ballots. Why don't we just shove them inside? The judge says, again, the court does not doubt Miss Honey's veracity, but her testimony is of limited use in making a finding that intentional misconduct occurred. For one thing, Miss Honey agreed during cross-examination that while she has not received the delivery receipt forms, she knows that the forms do in fact exist. She didn't get them, but they exist, right? And because Kari Lake has to bring the claim, she doesn't really get all that discovery like you might get in a criminal defense case, because you have a right to see the evidence against you in a criminal case. In an election case, it's all still kind of the purview of the government. Now, while Ms. Honey testified that the public records request has not yet been fulfilled, to the extent there is a claim to be made for insufficient production, that claim is not before the court. Okay, so Ms. Honey, right, or Kari Lake, if they're upset that they don't have the records, well, they can file a claim that they didn't get the records to do their investigation. But that's not what we're here for. And as Ms. Honey said, apparently the records do exist. They just haven't been given over yet. And so because Kari Lake's expert herself agreed that the forms, which are the basis for this claim, they do exist, Kari Lake cannot point to their absence as a violation of the manual, the election manual. But next, as to the 50 ballot packets that those Runbeck employees were allegedly shoving in the courier boxes, Miss Honey admitted that neither she nor her contacts with Runbeck had personal knowledge of any permission given by Maricopa County to do anything like that. Right? So again, no names of who would have authorized that, no intent by Maricopa County. The court also goes through some additional affidavits, somebody named Leslie White, somebody named Denise Marie. The White affidavit is less helpful on these points. Miss White testifies mainly to the limitations of what she was allowed to see as an observer. Okay, so her affidavit's just like, well, I think they were doing this, and I could sort of see that and sort of see that, but Judge says that Leslie expresses worry about the rapid pace of the processes and her limited field of view, but does not point to any violation, nor does counsel draw the court's attention to any violation found in the affidavit. Right? So they're not checking the boxes there. As for Miss Marie's affidavit, the court must weigh her averment that the family ballots were inserted into the ballot stream against sworn testimony of Mr. Jarrett and Mr. Valenzuela. Both those two gentlemen who came in and testified and said, no, none of that was happening. No, we would have never approved any of that. Right? These two guys, they actually run the elections, and they came in and they said, nope, never authorized anything like that. It's not part of the procedures. And don't believe them. They say they have eyes on the ballot process during their entire time at Runbeck. So the court finds the latter more credible, the election officials, given that Miss Marie does not even allege anything about the Maricopa County employees' roles in the alleged violation. So who in Maricopa County would have authorized that? Judge says that the combined testimony of multiple officials about the training, the violation, says we can't give that document much weight. Sorry, Miss Marie. Judge says that in his closing arguments, Kari Lake's lawyer argues that, quote, it does not make sense, right? And he said that many, many times. It does not make sense. It does not make sense. In fact, I stopped playing his closing argument because that was basically the argument. He says it does not make sense that Maricopa County did not know how many ballots Maricopa County had received on election night. But at trial, it was not Maricopa County's burden to establish its process or the procedure was reasonable, or that it had an accurate unofficial account on election night. Even if the county did bear that burden, failing to carry it would not be enough to set aside the returns. Particularly where Kari Lake's own witness on this point lacks personal knowledge of the intent of the bad actor, admits that the defendant did in fact generate the documents, and otherwise says that they did sort of otherwise comply with the processes, this court cannot say that plaintiff proved element 1 of count 4. No intent. Judge goes back over to Clay Parikh. Clay Parikh, of course, was Kari Lake's expert witness. Fun testimony from him. He was the individual who told us that there was a script that was written that updated the ballot settings. Here's what that sounded like. Actually, this is a very long clip. It's at the very end.
It's actually what would be called a print spooler, and it controls the print jobs to allow the printer to take on the load. And as there were multiple site books, this would be the technical use that laptop should be used for.
Is there any way, in your opinion, for a 19-inch ballot image to be projected on a 20-inch ballot by accident?
No, sir.
Why not?
Because the settings and the configurations and the procedures that are used cannot allow that. These are not a bump up against the printer and the settings change. There are security configurations. I've reviewed the evidence, and the printers are configured via script, which by any large organization that has to do multiple systems is a standard. This takes away the human error of somebody miscoding in the instructions either on the printer.
So somebody has to run the script. Somebody has to intentionally install, say go and update all the settings. So the next question, of course, after that testimony would be to go over to the government and say, who's responsible for writing your scripts? Is that true? Do you guys actually update your printers by script? Okay, when was the last time you updated them? Who authorized that? Did you talk to that person, that individual? Okay, we'd like to talk to him. Why has he not been disclosed? Why is he not a witness that was called by Kari Lake's lawyers? I have no idea. But anyways, these two guys, right, are also involved in that, and when they're brought up for cross-examination, we don't get really any questions out of them, right? No follow-up on Clay's opinion. Hey, Scott Jarrett, he said, our expert said it's updated by scripts. Is that true? Who wrote those scripts? We didn't get many questions about it, but let's see what the judge says about Clay. He writes, Mr. Parikh has an impressive technical background as a cybersecurity expert for Northrop Grumman. The court again credits his substantial experience and his personal knowledge as far as it goes. Now, his primary contention was that the printer errors he saw reflected in the law. He saw a printing of a 19-inch ballot on a 20-inch paper ballot. Must have been done intentionally, either by overriding the image file that was sent from the laptop to the printer or from the ballot image definition side, right? When you send a Word document over to the printer, you say, can you please print it right here and put it on 8.5 by 11? Or if you're doing an envelope, put it on an envelope and print it this way. You send the instructions to the printer. Either those instructions were changed in the software, or sometimes you just send a document over to the printer. You just say, print this. I don't care what happens with it. Print it. And the printer says, okay, fine. 8.5 and 11 by 11. You've got it. It just spits it right out. Or you change the defaults on the printer side. Either way, it's a change, right? That was Parikh's argument. However, if the ballot definitions were changed, says the judge, it stands to reason that every ballot for that particular definition printed on every machine would be affected and printed incorrectly. As Kari Lake's next witness indicates, that was not the case on Election Day. In either event, Mr. Parikh acknowledged he had no personal knowledge of any intent behind what he believes to be the error. He said that they had to update them via script, which means somebody made the change intentionally. But the judge is being very careful with that one. Okay, and I think where this is going is the judge is essentially saying that there was no person. There was an error, there was a script, there was something that happened, but who was the person who intended that to happen and where did the intent come from? The court notes that Mr. Parikh also acknowledged a fact admitted by several of Kari Lake's witnesses that any ballot that could not be read due to the printer or tabulator failure could be submitted for ballot duplication and adjudication for door 3. Plaintiff's own expert, meaning Kari Lake's, acknowledged that a ballot that was unable to be read at the vote center could be deposited by a voter, duplicated by a bipartisan board onto a readable ballot, and in the final analysis ultimately counted, right? This is the harmless error provision. Doesn't matter. It's harmless error. It should be counted, and it's going to be counted anyway, so who cares? Judge says, therefore, Kari Lake's expert on this point admitted that the voters who suffered from tabulator rejections would nevertheless have their votes counted. Italics. This, at a minimum, means that the actual impact element of count 2 could not be proven, the impact element. The printer failures did not actually affect the results of the election. And so the judge says further, as to the intent elements, the court must pair its consideration of Parikh's testimony with another witness called David Betancourt. David Betancourt is a temporary employee of Maricopa County, and we saw his testimony. He was the gentleman who said that it was madness and chaos, and he shared with us the text messages, many text messages showing all sorts of problems on Election Day. And we read through many of these, right? Lots of misreads. We're running at about 50% acceptance. Inspector from Mountainside in Tempe called and says tabulator is not accepting overvotes, even though they're pressing the overvote buttons and so on. Judge goes through his testimony and says, Mr. Betancourt was a temporary employee of Maricopa County called a T-Tech, called by Kari Lake to testify about the technical issues. As relevant here, the judge says Mr. Betancourt testified that there were, in fact, multiple technical issues on Election Day. He said that these were solved through a number of various means. 1, taking out the toner and ink cartridges and shaking them, which is a solution that most of us have tried. 2, cleaning the corona wire. 3, letting the printers warm up, cleaning out the tabulators. 4, 5, adjusting the printer settings. Man, a whole lot of different things that went wrong. It is of note, apart from 5, that none of these solutions implicates a ballot manner suggesting intent. all of those sound like just regular office problems. Oh, got to clean the tabulators, adjust the printer settings, got to shake them a little bit, bang it on the side, turn it off, turn it on again, the whole deal. Adjusting the settings. And none of that sounds like intent. It seems like just a bunch of innocent problems happening. Mr. Betancourt testified that each of these on-site actions were successful to varying degrees, with shaking the toner cartridge being the most effective. Oh, that's all this was. It was just shaking toner cartridges. Judge says it's worth repeating that ballots that could not be read by the tabulator immediately because of the printer settings could be deposited in door 3 and tabulated later. So its harmless error doesn't matter. Judge says that the Maricopa County Tech testified that not only did he lack knowledge of any other election worker engaging in intentional misconduct, right? He was asked during cross-examination, did you screw this up? Did you ruin this election? He says, no, I didn't do it. Did you see anybody else screw this up and ruin this election? No, I didn't see anybody. Does anybody want to come forward? Anybody want to come forward and be charged with multiple felonies and tell us that you screwed this election up? No? That's weird. Gosh, it's weird. There's no witnesses to talk about this. Strange. But further testified that T-Techs he worked with diligently and expeditiously troubleshot each problem as they arose. And this is what the government was presenting. They were saying, we had people trying to fix this all over the place. What are you talking about? How could we want this to go off the rails when we want the problem solved immediately? We want them fixed like around 2 o'clock after the election's mostly over. They say that they wanted to troubleshoot the problems. They were doing so in a frenetic election day environment. And Kari Lake's own witnesses testified before this court that the printer failures were largely the result of unforeseen mechanical failures. The judge brings in our friend Richard Barris. He's all over the internet. Make sure you're following him at peoples_pundit. He's on YouTube too, right next door. Richard Barris is here. He says, the judge says about Richard Barris, he says, Mr. Barris testified as the director of Big Data Poll. He testified that as a result of the printer failures, a number of voters were disenfranchised. And he opined, says the judge, that this change resulted in Kari Lake losing the election. He testified that he knew this was because of the decreased response rates to his exit poll for the general election. The court will, with respect, put aside the ongoing internecine fights amongst pollsters and political scientists as to the methodology and the reliability of what they do. Indeed, giving weight and all due credit to Mr. Barris, he does not prove element 4, an actual effect on the election. Because it's just speculative, right? It's just him saying that this is what I think, this is what I'm getting, this is what I have seen in the numbers, but it's actual effect. Like they got to go find some votes. Specific buckets of identifiable votes. Bucket from chain of custody, transfer, courier, item 37, 55, 12, whatever that batch is. Further, Mr. Barris admitted at trial that nobody can give a specific number of votes who were put off from voting on election day, which is true, right? And this is a big point. This is what I thought really, if we lived in a country that cared about process, right? Like an election going appropriately so that everybody trusts the outcome. The fact that you can't quantify the people who didn't show up to vote because of the delays. You can't put a number on that. Now, the government tried to do that, right? They tried to sort of argue in circles a little bit or actually narrow the hula hoop when they brought out this guy, Dr. Kenneth Mayer. He told us that the people who showed up on election day who checked in, they all voted. Most of them. He identified 100 or 110 different ballots of those people who checked in and then left without casting a ballot. They said, F this, I'm done. But what we didn't hear is the people who didn't check in. How many people drove by at 6 a.m., 8 a.m., 10 a.m., 12 a.m., saw the lines and didn't go vote? They had to pick their kid up from school. They had a meeting they were late for or whatever. Or they just thought Kari Lake's going to win, so I guess I'll just stay home. I was intending to go vote and I didn't go vote. That's voter suppression by anybody's measure. And if you brought this up in Georgia and this was happening to Stacey Abrams' constituents, she'd have a different opinion. She'd agree with us here. But because it's Kari Lake and it's a bunch of Kari Lake voters and it's Arizona and it's, they're happy as hell it's going blue, nobody cares. In fact, I think the Republicans are even happy about this. Right? Doug Ducey and the rest of the conservatives here, many of them would rather see their team lose than see another star player win the game. Okay, Doug Ducey got sidelined. Everybody's being backbenched now. Kari Lake's the new star of the team. They don't like that. So they'd rather their whole team lose the game and have the other team win than have a star player like Kari Lake win. So they all shut their mouths and everybody gets quiet about this. But there's no number at the top of the funnel. How many people were suppressed or discouraged, disenfranchised at the outset? Don't know. Richard Barris was brought in to try to quantify that for us using data that's outside of the system. Exit poll, right? Does the government know? Do they have a number on this? No, because they're not tracking you to go to the polls and so on. So you have to use external data to get that number. And the government didn't provide it. But guess what? They're not required to provide it. It's Kari Lake's burden. So they did the best they could. They brought in Richard Barris. He says nobody can give a specific number. Thus, they write, even if Kari Lake proved elements 1 through 3 by clear and convincing evidence, the truth of this statement alone dooms element number 4. Because you can't prove that number, and the judge wants a specific number. No election in Arizona has ever been set aside. No result modified because of a statistical estimate. In this court's view, it's a quantum leap to go from analogizing cases where a malfeasance was precisely quantified such that the court could provide a remedy. In other words, we've identified 17,200 votes that were illegal, which allows us to reverse this thing. A hard number from specific batches and buckets. The judge says, no, we can't do that. You want us to go from this estimate to setting aside a result where the result of the alleged malfeasance is itself unknown? Judge says no. In cases where, for instance, a proportionality method was used, it has been to remedy a known number of illegal votes cast in unknown proportions. Judge takes us back to another 1989 case. But election contests are decided by votes, not by polling responses, and the court has found no authority suggesting that exit polling ought to be used in this manner. Given that exit polling is done after a vote has been cast, the weight of authority seems to be contrary to this proposition. Right? It's a good effort, right? I thought, it's about the only thing you can do is to bring in somebody like a pollster like this to quantify that number. But it was a long shot from the beginning because the judge wanted, he told us, a specific articulable number. Judge gets to it. He says, indeed, to the extent that a range of outcomes was suggested by Barris, he suggested that with his expected turnout increase on election day, says that about 25 to 40,000 votes would have impacted this. It could be between a 2,000 vote margin for Hobbs to a 4,000 vote margin for Kari Lake. So, taking Mr. Barris's claims at face value, this does not nearly approach the degree of precision that would provide clear and convincing evidence that this was the result of the printer failures. Judge says, well, while this court, even in the absence of a controlling authority, is hesitant to state that statistical evidence is always insufficient, that what the judge is saying is that even according to Richard Barris's testimony, the current winner still had a good chance of winning anyway. And so you can't do much with that. Judge says that Mr. Barris cannot say, and further, there was no evidence at trial, that these voters were turned away or refused a ballot. These were voters who elected not to vote, whether at a vote center due to long lines or due to media coverage of chaos on election day or any other of unknown reasons, right? So the fact that it was basically, it was almost impossible to vote that election morning at certain locations, that's not voter suppression. Actually, the judge is not making that argument because voter suppression is not the threshold. Right? It's not the standard. Now, you and I know that that's clearly voter suppression, right? If that was happening to Democrats, like, for example, if we just said, well, there was chaos on election day at Runbeck when we were counting the electoral ballots. There was chaos in the printer scanners that were scanning all of the early voting ballots, not the electoral, right? All early voting ballots that came in from largely Democrats, when we were counting them on the printer scanner machines, there was chaos there. Whoa, whoa. It was madness, but don't worry about it. There was, some problems and there were a bunch of texts, scrambling and everybody was freaking out, but don't worry about it. You can trust us. Everything's fine. right? They're different standards. They're saying that Barris provided some good speculative evidence, but not enough to close that gap. None of these constitutes direct evidence permitting the court's intervention. Barris's testimony does not show by clear and convincing evidence that there was misconduct around the printers. Therefore, it doesn't fit. The judge says, we have to talk about the intentional misconduct standard. Now, the court makes the following observations about Kari Lake's case as a general matter. Every one of Kari Lake's witnesses, and for that matter, the defendant's witnesses as well, Hobbs's, the government, was asked about any personal knowledge of both intentional misconduct and intentional misconduct directed at the impact the outcome of the election. Every single witness before the court disclaimed any personal knowledge of such misconduct. Yeah, we were waiting for a name the whole trial. One name, just one. The court cannot accept speculation or conjecture in place of clear and convincing evidence. The closest that Kari Lake claimed to making an argument for quantifiable changes resulting from misconduct was Miss Marie's affidavit, as discussed by Miss Honey. Again, she states that Runbeck election employees were permitted to introduce 50 ballots of family members into the stream. Great. Guess what? We've got an employee that would have a name, presumably. We've got a number, 50 ballots. Great. We have a quantifiable amount. We have some malfeasance, right? Misconduct, inserting the ballots into the stream, misconduct. That's another element. The question about the 50 would be, does that impact the outcome of the election? Obviously not. Was it done with the intent to impact the outcome of the election? Probably not, because it's only 50 ballots. But even that is not sufficient. Such a claim, if the court accepted the affidavit at face value, would be misconduct, but it would not come close to clear and convincing evidence that the outcome was affected. It's only 50 ballots. Who cares, right? Though again, now we care, I care, but the court doesn't care. You want me to throw out a whole election because somebody opened up a zipper and shoved in 50 ballots? Not going to do that. Though again, weighing her affidavit against other testimony, the court does not give the affidavit much weight. They write, Kari Lake failed to provide enough evidence with which the court could find for her on either count by clear and convincing evidence. And to the extent that certain claims are contradicted by the defendant's case in chief, it's unnecessary to go into extensive detail, but a few points are worth noting. They write, judge says, as Ray Valenzuela, co-director of elections, said, there was no direction, no permission was given to Runbeck to allow them to do that. Scott Jarrett, also another co-director, and Stephen Richer, county recorder, each testified that Maricopa County election workers are trained to follow the rules and that to their knowledge they did. As noted above, Valenzuela and Jarrett testified that Maricopa County employees were observing the ballots at each stage in the process. We were watching everything. Kari Lake brought forward no evidence to contradict that. Judge says it bears mentioning that election workers themselves were attested to by both plaintiff's witnesses and defendant's witnesses about being dedicated to performing their role with integrity. Not perfectly, as no system is perfect, but more than sufficient to comply with the law and conduct a valid election. Therefore, the judge issues findings of fact and conclusions of law, saying, as to count 2, Kari Lake, the allegation that there was illegal printers and tabulator configurations, the court does not find that there was evidence of misconduct. The court does not find that such misconduct was committed by an officer of Maricopa. The court does not find that that misconduct was intended to affect the result of the election, and similarly, no finding that there was any misconduct that did, in fact, affect the outcome. A person, misconduct, intending to adjust the outcome, did, in fact, adjust the outcome. 0 for 0 on that one. Count 4, chain of custody, same thing. Court, no clear and convincing evidence of misconduct. Not done by an officer, not done with the intention of affecting the outcome of the election, and not done, in fact, impacting the outcome of the election. So the judge says, in conclusion, it is ordered confirming the election of Katie Hobbs as Arizona governor-elect. Oh, gross. Oh, man, that felt horrible to read. Oh, yeah, sick. Taste in my mouth. Oh, gosh. All right, let's carry on here. The court notes the representations of the county defendants that a motion for sanctions against Kari Lake is going to be coming soon, too. And it's further ordered that a statement of costs, including compensation of inspectors and so on, is going to be filed Monday, December 26th, tomorrow. And any motion for sanctions also must be filed by 8 a.m. tomorrow, and any response by 5 p.m. tomorrow on Monday. So we'll have some more motions for sanctions tomorrow, which will be fun. So hopefully all those board of directors are fervently typing away on their motions for sanctions right now to get that all dropped over in the court tomorrow. Merry Christmas, everybody. Arizona. Bah humbug. The Grinch just came and stole our Arizona from us. Well, that, my friends, is it for the Kari Lake decision. Not a good decision. Here in Arizona, we've got to live with that garbage, unfortunately. And of course, if you are in Arizona and you happen to know anybody charged with a crime, there's our law firm and our phone number if you do need some help. But Kari Lake is going to be appealing this. You see here, she's got an appeal likely already pending. Her lawyers are going to be reviewing the record. I am not optimistic about the appeal because I agree with the judge. I don't think that she proved those elements. Now, I have a disagreement with the law. My opinion on this is that the mere suppression of votes on election day is sort of enough evidence you need. There's a concept I was thinking about in the law called re ipsa loc. This is an old Latin phrase. Nobody knows how to say it. Re ipsa loquitur is the thing. And it's an interesting phrase in the law. People call it re ipsa loc or res ipsa loquitur. A lot of people say it differently. It comes from tort law, but it basically means the thing speaks for itself. Okay, the thing speaks for itself. It's a doctrine in common law where a court can infer negligence from the very nature of an accident or an injury, right? You don't even need direct evidence because the fact that it happened means there was a catastrophe, right? It's not something that applies in election law. I think that if you have an election where a giant percentage of the electoral polling places are problematic, it kind of speaks for itself. The thing speaks for itself. In tort law, right, if there's an accident that happens and it's such an obvious accident, it's like you don't need to prove that somebody was negligent because the accident happened, right? It's such a disaster that there's not even a case to debate. So here, for example, here's a fictitious example. John Doe is injured when an elevator he has entered plunges several floors and stops abruptly. Okay, he's in the elevator just falls. Do we need to prove that there was an accident that occurred? No, because the elevator fell. So, like, do you need to prove that the elevator company or the building manager was negligent? No, because the elevator fell. Jane's Corporation is built, responsible for maintaining the elevator. John sues Jane and so on. The court says John does not have to prove anything beyond the fall. If you fell, that's enough because the elevator malfunctioned. Jane was responsible for the elevator. Jane's Corporation is responsible for the fall, right? I think the law of elections should be more closely, aligned with some of these principles because in this situation, boy, we had a disaster in Arizona. The whole country knows it. The thing speaks for itself. The judge is going to turn himself into a pretzel to hold the election and to comply with the law. And the judge's opinion, I think, is actually right, because Kari Lake didn't prove the elements as written by law. But the law is kind of ridiculous. The thing speaks for itself. Re ipsa loc. In Arizona, the election was a disaster. We all know it. And we'll see how Katie Hobbs' new reign of terror is as she takes over. But we will, of course, continue to cover all of this news and more. Thank you for liking this video wherever it is you're watching. Thank you for subscribing. And Merry Christmas wherever you're tuning in from.